In breaking news, we've got our first injunction by a federal judge following Friday's Supreme Court attempt to limit the ability of federal judges to issue injunctions against the Trump administration. Judge DuBose up in Rhode Island has blocked the Department of Health and Human Services, run to the ground by RFK Jr. She's put a stop. She said his actions are arbitrary and capricious. The attempts to sever the relationship between America and its health, between America and its health services, she's blocked it. And then she said, I'm issuing an injunction. I got 19 states on one side. I got the federal government on the other. I have to stop the federal government trying to not make America healthy again, but make America sick. When I get through telling you all the agencies and departments and programs and funding that the Department of Homeland Security is in charge of, related to children's health, pregnant women's health, tobacco regulation, cancer screening, and the rest, all being destroyed by Donald Trump. And Judge DuBose said, listen, I know there's a decision on Friday from the United States Supreme Court about nationwide injunctions, but I got 19 states, and I think I've got an exception. And I think my injunction is not too broad. But you guys tell me, do you think there's anything about Friday's Supreme Court decision, if at all, that stops the scope of my injunction? She's challenging them, the Department of Justice and the Trump administration, to tell her why her order isn't compliant with the United States Supreme Court. That's the right place to be. You're on the right place. You're on the MeidasTouch Network and on Legal AF. I'm Michael Popok. Let's get to it. Judge DuBose. There had to be a first, and I am pleased that it's Judge DuBose. She is one of the youngest judges. She's the first black judge on the Rhode Island federal bench, the first openly LGBTQ plus judge, and a Biden appointee from about 6 months ago. Super bright. Here's what she had to write. You can almost hear the dripping sarcasm of Judge DuBose in her 60-page decision, her 58-page decision. Here's how she starts it on page 2. This is against Department of Health and Human Services. Yet another group of plaintiffs seek relief from a federal court to halt sweeping changes to a federal agency's operations, which they claim disregard congressionally mandated programs to the detriment and peril of all who live in the United States. And then she continues and talks about the 19 states. She then dispatches quickly the challenge by the Trump administration. She says on page 3 that it is the tired litany of opposition that has been raised by the Trump administration. She says this hodgepodge of challenges will be familiar to those who are tracking the dozens of cases around the country, similarly challenging the Trump administration's efforts to reduce and reorganize the federal government. She then says that everything the Department of Health and Human Services has done is arbitrary and capricious, which is a term of art, which means that under the Administrative Procedures Act, if you're going to make changes, you're going to try to reorganize agencies and departments and sub-agencies out of existence, you can't do it in an arbitrary and capricious fashion. And everything that RFK Jr. does is arbitrary and capricious. He even admitted, he says, well, I don't know. We're probably cutting too many people, he once said. We'll probably have to rehire 20% of them. You think? And she says, because it's arbitrary and capricious, she never has to reach whether it also violates the separation of powers under the Constitution. She then goes through all the ways that the states, the 19 of them, have been irreparably harmed, and has to, by extension, explain all the different ways the Department of the Department of Health and Human Services impacts Americans. They run the Center for Disease Control, related to birth defects, developmental disabilities, occupational safety, HIV, STD prevention programs that impact the federal poverty guidelines, the lead poisoning programs, reproductive and maternal health programs, all at risk, undermined by Donald Trump. Particularly, she says, your position as the executive branch is to execute the laws, not to undermine agencies established by Congress and funded by them. At the end, let me read to you from her actual ruling. Scope of remedy and order on page 55. This is the first federal injunction from the Friday decision by the United States Supreme Court that left open the question of whether, if there are states involved as plaintiffs, whether a nationwide injunction can be issued. Either way, if she's not allowed as a federal judge to issue an injunction, then what is the Supreme Court saying? That a federal judge can only declare out loud that something is unconstitutional or violates the Administrative Procedures Act, but can't do anything about it in the interim, can't grant interim relief, can't grant an injunction. It has to be let the destruction happen as it wends its way to the United States Supreme Court. Only the Supreme Court can block it. That can't be the law. She says here, the states are asking this court to enjoin the mass terminations and restructurings resulting from the March 27th communique to all these different departments. The agency asked the court to limit any injunctive relief to address any information or services to which it is determined that the states have established an entitlement. Here's her ruling. The preliminary injunction is granted. HHS and all other defendants are enjoined from taking any actions to implement or enforce the planned reduction in force or the restructuring or the defunding. She said the party shall file a notice with the court on or before July 11th addressing the way in which, if at all, Trump versus CASA Incorporated, the case from Friday, impacts the scope of this order. She's saying, I don't see that this is violative of the Supreme Court precedent about injunctions. You tell me if you think it is, which I think is the right way to go. And then she has to get to bonds because the courts are now required to consider a bond amount. But she says, given the tremendous amount that the states have plenty at risk in this case, she said she's going to impose a nominal bond of $100 and grant the stay. And she's not going to stay her order to allow for an appeal. So we're going to continue to follow it. This is important stuff, everybody. This is the first injunction by a federal judge following the Supreme Court's ruling on Friday. And it's important for you to have known it. I'm glad I was able to discuss it with you here in brief you want it here on the MeidasTouch Network and on Legal AF. Take a moment, hit the free subscribe button for Meidas. Come on over to Legal AF, the YouTube channel, and hit the subscribe button there as well. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.